In addition, at some point in time during the program, actually 45 minutes into the program, we will open the lines and we'll have an opportunity for the public to engage with some of the subject matter we'll be covering. As we indicated earlier, this is rather a teaching program, so part of the idea is to make sure that it is an interactive platform between ourselves and you out there. So those of you 45 minutes into the program who would like to engage with some of the topics that we'll be covering today, you can do so on 0880 514 and I'll repeat the number again, 0880 514 096, and you'll be able to engage directly with us to few comments, to few questions, amongst other things. We'll take a few more bars of our theme song, and when we return, we'll then begin to look at some of the key foundational issues that we want to start off a conversation with before we then move in subsequent edition to issues of law. I'm free now, baby. I'm free from your spell. Free now, baby. I'm free from your spell. Now that it's all over, all I can do is wish you. So welcome back to What the Law Says. As we indicated earlier in this maiden edition, because this is a teaching platform, part of the idea is to start off by giving those of you who are listening working understanding or working definition of context of law. And while it's important to have that background before we then move into other substantive issues of law subsequently in other programs that we will be hosting here on this platform. To start off the foundational conversation about law, there are a number of topics that we have carefully curated because we understand that to have any conversation about law, it's important to have a basis, to have a background, to have a foundation. And there can be no conversation that helps you to understand law or the legal framework in which any country, any jurisdiction for that matter, operates if you don't have the basis to understand. So, in order to help us to begin that process of teaching and learning, which we hope to accomplish over the lifetime of this program, our foundational conversation will cover a number of very, very important topics here today. First, we're going to look at what is it do we actually mean when we say law. I know that a number of times, or quite repetitively in the public space, we all, meaning Liberians, have used, oh, it's a question of law, or there's a law violation, there's an issue with laws being broken. But when one says law, what actually does one mean? And it's important to start out by looking at a working definition of what law is. But beyond just looking at that definition, we then want to go further and unpack that definition word by word and try to understand in clear details, even with examples, what actually law is. After we've done that, we then move to then look at what we term as the rule of law. Because ultimately, the question then becomes, so there is law, but what is the necessity of law? Why do we even aspire to be a country governed by laws? And then that brings us to talk about this whole idea of the rule of law. And therefore, after we answer that question of defining and explaining what law is, we'll look at what the rule of law is. And whilst doing that, we'll look at what we call the fundamental tenets that should underpin the rule of law. After we've done that next, then we will dovetail into looking at the role, or what I term as the function of law in society. And there are a number of functions. We have some time to discuss that and explain that, because we believe that it further entrenches the learning around the definition of law, or rather the question of the rule of law. And after we'll have we shall have laid that fundamental basis by saying this is law, this is the rule of law, what role or function law plays in our society. Then we start off by then looking at least at a preliminary level, the Liberian legal system, or giving an overview of the Liberian legal system. And after we've done that, we'll look at where we get our laws from, the sources of law. And at that point, we'll pause and then hopefully have some interaction from you out there in Radio Land. So let's follow up and let's have an interaction and a teaching experience on some of these very, very important things. So we start off by asking, what is law? In history or in philosophy or in most of the different areas that I've tried, even in religion, that I've tried to grapple with this question of law, there have been various definitions that have been promulgated by those who have studied the concept of law. Many, many definitions, and they've been enumerated in many treatises, as I said before, whether it be in literature or it be in religion, they are there. But as lawyers, most often when we have to define a critical legal term, and as lawyers would normally say, we tend to take flight to what we term as the legal Bible. And for most of us, the legal Bible, for definition, nowadays happens to be the Black's Law Dictionary. For those of you who have undertaken scholastic work, you know that most often when you have to define key terms, you will run to the Merriam-Webster Dictionary. In the case of lawyers, we often run to the Black's Legal Law Dictionary. So let's see exactly how the Black's Legal Dictionary defines law. Let's look at it word for word, and after that, let's make an attempt to unpack exactly what that means. So the Black Law Dictionary goes on to define law as a body of rules or action or conduct prescribed by a controlling authority having binding legal force. It goes on to explain that it means that such rules or authority must be obeyed and must be followed by citizens subject to sanctions or legal consequences. That's how the Black's Law Dictionary defines law. That is about rules, it's about action, it's about conduct. It must be prescribed. There must be an authority, a controlling authority that makes that prescription, and it must have binding force. There are a number of key words that are there that we ought to look at with some level of depth in order to be able to fully understand then what law is. So the first thing we start off with is that it's a body of rules. As most of us out there in Radio Land are aware, rules are basically prescriptions or are basically ideas put out there that are intended to guide conduct. And it can range from something as very simple as when you live in a household and you are minor, meaning you are underage and you live with your parents. And your parents basically say to you that whilst you live in this house, you must return home by 7 o'clock. And you can remain out of the house after 7. That's an example of a rule, meaning it is something that is intended to direct conduct. The second word we must pick up out of this definition then is that it's prescribed by a controlling authority. Let's go back to our example about living in a house with your parents and you are underage. So in that case, if we look at the question of a controlling authority, authority in this case happens to be your parents because they preside over the household. And in the process of presiding, they set what are the rules that govern action, as we indicated earlier, in the household. But for it to be law, there cannot just be prescription or the act that these rules are put out there by the controlling authority. Our definition from Black's law goes further to say that it must have binding legal force. In other words, what they're saying is that, one, you must have an authority, meaning someone who has, or some institution that possesses the power to produce those rules. And when that institution or that person or that group produces the rules that governs your conduct, if there is any transgression, meaning if there is any breaking of that rule, there is a consequence and it has binding legal force. So at an elementary level, let's go back to our example that we gave concerning living at home with our parents. If we hypothesize and say that our parents having to be are the controlling authority, and they create this rule that you don't come home after 7 p.m., and that is the rule of the home. If you were to come home after 7 p.m., understandably, parents will set prescriptions for what is supposed to be the punishment or whatever that comes as a result of that infraction. So, again, reverting to black, we say that laws are basically rules. And many a time, people get caught up, and it's important to clarify this point, in the semantics of defining law, meaning in the fact of the words rather than the action. As some of us are aware, those who are involved with literary enterprises will say that if it quacks like a duck, then it must be a duck. In other words, what we're saying that rules or ordinances or any kinds of prescriptions that are put out into the public space that govern conduct whose breaking can lead to penalty can be classified as laws. It's not so much so that they are labeled as laws or they are called laws. They may be called regulations. They may be called ordinances. They may be called many other things, statutes. But the key thing is to understand what is the working definition. If it is given by a controlling authority, meaning that whoever puts out that rule has the right to put out that rule and has the right to enforce that rule, and that if you don't obey that rule, there is punishment to follow, then we can say in this particular situation that it is a law. And it may not be termed as a law, it may be called a regulation, an ordinance, or whatsoever, but don't get caught up in the nomenclature or the words or the semantics. The idea is about the definition that laws have consequence, they govern people's conducts, and when they are broken, consequences follow as a result of the breaking. So that is law. Now, I gave an elementary example utilizing the home as an example for a controlling authority and using the curfew as an example of a rule or that is provided as a law whose breakage could lead to potential penalties. But the whole idea here is that in the global or in the state setting, then laws become about the government or the state setting certain rules that ought to govern generally everyone within what we term as the jurisdiction, or some may say the bailiwick of that particular country, whose violation then brings upon sanctions or punishment by the controlling authorities, so to speak. So there we have our working definition of law. And it's important to understand this definition. That's why I keep going back and repeating that it is not the question of whether it is termed as law, but it's whether it functions as law. So if it restricts conduct, if it comes from authority that has a right to impose it, if the breaking leads to sanctions that are enforceable by law, then we can say that it is law. Now, that brings us then to our second topic that we're supposed to cover today. And it's a nice segue or transition into that topic, because oftentimes you have a conversation about law and folks will ask you, but yes, I mean, law in and of itself as a discipline is important. It is nice. We want people to be lawyers. We want them to be doctors. These are very well acclaimed disciplines. But why is it important? Why are they acclaimed? So why law in the first place? And that is what brings us then to have a conversation about what is meant by the rule of law, which is our second topic. Because for ages, men have argued about whether there was a need for regulation or a need for law. Oftentimes in society, we argue like, to what extent can we be free? Can we go? And why must our actions be restricted by a controlling authority that exercises control over how we behave and what we do? And I believe that this whole concept of the rule of law, meaning that laws are important and laws must rule as opposed to men ruling, evolve as a validation of the fact that laws are very, very important. And if we even trace back to very early history, early in this time, I mean, in the development of jurisprudence, especially in the development of international law, part of the idea of saying a rule of law emanated within the discourse of the post-World War II era in other countries where at certain trial people believed that if we did not have a framework for constraining how humans behave in regards to each other, then there will be chaos. And of course, when there's chaos, there's a lack of development. When there's a lack of development, everything breaks down, people perish, there's no socioeconomic development, and so to speak. And that is why it's important for us, the natural transition is to look at the rule of law. So, what is the rule of law? If we were just to take the topic by itself or the statement by itself and say rule of law, ordinarily we'll arrive at a point by defining what it means to rule, and we know to rule means to exercise control over. And then what we say by adding the adjective, the adjectival portion of the statement to say the rule of law, then we'll basically be saying it is ruling or governing under the ambit of law, or allowing laws to be the tools through which we rule or through which we govern. And that is what we'll say if we're just looking at the statement. But then a lot of scholars and thinkers have spent more time going beyond just the literal definition of rule of law as I posited just now, as I've explained just now, but going in to say if we must categorize a particular area or a particular sector or country as having the presence of the rule of law, what must it entail? And these group of scholars still exist today in the form of an organization called the World Justice Project. So the World Justice Project is the preeminent organization that works on rule of law around the world. Every year they compile what is referred to as the rule of law index, which looks at how countries around the world are faring in terms of the administration, in terms of utilizing a rule of law framework in their various countries. But that is beside the point. The point is, how have these very illustrious scholars and thinkers and practitioners come out to then define the rule of law? They gave us a working definition. According to the World Justice Project, they say that the rule of law is a durable system of laws, institutions, norms, and community commitment that delivers 4 critical results. I'll emphasize them again. It's a durable system of laws, institutions, norms, and community commitment that delivers 4 critical results. Before we look at the 4 critical results that are delivered, because the results are at the tail end, they argue or they postulate that if the rule of law as defined exists, it is supposed to deliver 4 critical results. And we'll look at those 4 critical results that must be delivered. But let's look at the working definition. The first thing they say is that the rule of law is a durable system of laws. And I like to take some time to emphasize the word durable. And we all, I'm sure, for the most part, those of us who are listening to this program have at one point in time or the other used the word durable. And when we say something is durable, even though we tend to use durable most often when we talk about tangible objects or fixed assets, so to speak, but we're very clear that Durable simply means that something lasts, something that is sustainable, something that can withstand assault or can withstand the test of time, as we put it. Most times when we hear even folks talking about durable, they will actually point out something like tires that we use on our cars, because these are some of the things that last very long. But it's important to situate durable in this case within the ambit of the rule of law. And the Word Justice Project starts off by saying that the rule of law is a durable system of laws. And that's the first attribute. A system of laws indicates to us that it is important, that it is necessary, that in whichever context or jurisdiction that we are looking at, and when we talk about context and jurisdiction in law, we're referring to countries or territories that are autonomous for the most part, meaning they have their own governing system. So a system of law means that things do not happen just by chance, or things are not invented just by chance. That these things that are happening, there are always rules that prescribe how they happen. So a system of laws means that within that particular country, within that particular entity, they have come together over a period of time and produce what they refer to as a process or a system that has laws. But for the Word Justice Project, for it to qualify as having the rule of law, it must be durable, meaning that over a certain period it must have lasted, and it continues to function, and it continues to act consistent with why it was created. Now, not only does the Word Justice Project say that it must be a durable system of laws, they go on to say that it's also about institutions, it's about norms, it's about community commitment that deliver the results, which we will talk about very shortly. I like to emphasize less the institutions and more on the norms and the community commitment. Because for the institutions, I believe that they have been, if you ask me for lack of a better word, overflogged. So we have a sense, meaning there's been a lot of commentary about institutions. So in a rule of law setting, when we talk about institutions, we know we're talking about administrative institutions that provide or that regulate law. And in this case, I don't want to jump the gun because we'll be moving to the legal system at some point. But they talk about those entities that administer law. And these are not only the ones that are the usual suspect like the judiciary, but even in the executive branch of government, there are institutions that are there that administer law. And even if we went into the legislative branch of government, it can be argued that there are institutions within the legislature that administer laws. Because when you have standing committees that are in the Senate that do confirmations consistent with law, it is a form of implementing rule of law. So the World Justice Project says that, one, the system of laws that have been put out must be durable. Second, it says that the institutions that are utilized to impact or to effect or to implement these particular systems of laws must also be durable. But they also point out that the norms and community commitment must also be durable. And that's what I said I wanted to spend some time talking about the norms and commitment, community commitment. Oftentimes, we say norms are things that are formed, embedded in society. And they oftentimes are not things that are legislated, meaning they are not written down or passed into law, but it's generally how people act or how they engage or how they perceive or the perception about certain things. For example, in Liberia, if certain things occur, we are prone to say, it's just Liberia, man, or that's Liberia for you. In other words, we're saying that even though there are rules that govern certain types of conduct, but these are the norms that underpin those conduct, that the norms don't necessarily match with the rules that are prescribed on the books. Because people are a certain way, but we have rules that are obligating them to behave in another way. The other thing is about community commitment. Community commitment is the fact that, look, you can have the institution that you administer law, you can have a system of laws, but it is the community, by the collective effort and commitment, or the collective buy-in of the community, that ensures that laws are implemented and laws produce the desired ends that they ought to produce. So, having said that, looked at the World Justice Project's definition of rule of law, meaning there should be a system of laws, they ought to be durable, there must be institutions that can implement laws, they must also be durable, long lasting. Then also there must be norms in society that support these kinds of laws that we always refer to. It's not a question of whether it affects me or it affects you. It's about what it must affect everyone, and then there must be community commitment. And the World Justice Project argues that if all of these things are present, then they should give rise to four critical results, meaning four things that are supposed to happen within any particular country that espouses or that projects the rule of law. The first thing they point out is that there ought to be accountability. I know accountability is another word that we've used quite repeatedly, but simply put, accountability is simply the question that folks that have a role to play are supposed to be transparent in how they play that particular role. But in terms of further defining what accountability is, they go on to say that it is not only the government that is supposed to be accountable, but even the private sector is supposed to be accountable under the law. Most times in a society, when we speak about accountability, we tend to speak from the governmental side. The government must be accountable. But the private sector, which includes private citizens as well as businesses and other people operating within the business domain, if we're talking about the rule of law and offering a critique, it's important, as projected by the World Justice Project, that not only it is government, but also that those within the private sector or private citizens and businesses are also accountable. And that's one of the first results that the World Justice Project talks about. The second thing they talk